Dear colleagues, Hague network of judges, central authorities across the globe, and the leadership of the Hague Conference, family law practitioners, representatives of member states of various Hague conventions, ladies and gentlemen from respective disciplines in the context of Hague conventions, good morning, good afternoon, good evening. I am Baratang Constance Mocumie. I am a judge in the Supreme Court of Appeal of South Africa in Bloemfontein, and a liaison judge in the International Hague Network of Judges. I am pleased to join the Hague Conference on Private International Law, abbreviated HCCH, today to participate in the HCC Approach global event in celebration of the 25th anniversary of the 1996 Child Protection Convention, hereafter referred to as the Child Protection Convention. The Child Protection Convention comprises of 7 chapters which have been explained and summarized by the Hague Conference in the explanatory note on specific matters concerning the 1996 Convention. My task is to focus on the concept of parental responsibility in its context, as I do in what follows. When examining parental responsibility, it may be easy for newcomers and veterans alike to get lost within the broad convention meaning, or to seek clarity on practical application of the convention provisions concerning parental responsibility, or to look into the development of national laws, legislations, and terminology encompassing parental responsibility. While these are important considerations, I take this opportunity to invite everyone on this platform and beyond to set these mechanics aside for a moment, to take a step back to reflect on the words themselves, and to explore our ordinary instincts about them. What does it really mean to wield the responsibility of a parent? What values, behaviors, or attributes come to mind? My personal instinct is to start by thinking about parental responsibility as a fundamental human role and relationship, that of the caregiver to a child. From this idea, we can begin to think about the many forms of support that a caregiver provides to a child. We would hope, in the best of circumstances, that children receive the physical, emotional, and spiritual support they need to live rich and fulfilled lives. But we know from our line of work, and perhaps from our own lived experiences, that the performance of parental responsibility is not always so optimal. Nor should we bind ourselves to thinking of parentage in troops that demand a picture-perfect upbringing, the parent-child relationship, the structure of the nuclear family, the day-to-day work that is required to meet the shifting and growing needs of children. These are complex and individualized matters that escape our tendency to categorize. And the benefits accruing from the exercise of parental responsibility are all the more crucial in situations where the family relationship is precarious or fragile. Families are created, they separate, and perhaps later join together in new configurations. Families are split across borders for various reasons, voluntary or involuntary. In the absence of nuclear family, the parental responsibility can also be conferred on relatives, grandparents, or other trusted figures. I think you will agree with me that the complexity of parent-child relationships is reflective of our changing world, as well as reframing over the years of how societies perceive the role of parents with regards to children. Turning to this convention and related instruments, we can see that a similar growth occurred on the international stage, as well as the regional stage, embodied in treaties of both public and private international law. First, I invite you to note the timing of the 1996 Child Protection Convention, which has siblings in the 1980 Child Abduction Convention and the 1989 UN Convention on the Rights of the Child, what we abbreviated as UNCRC, which came into force in 1990. At the risk of offending some of the youngest children in the audience, I observe the youngest often seem to escape the harshest scrutiny of the parents, but benefit greatly from watching their older siblings grow up. And so too, as the youngest child, the Child Protection Convention has benefited from the experiences of the 1980 Child Abduction Convention and the 1989 UN Convention on the Rights of the Child, which helped attune the focus of the international community on both practical and normative ways to secure the best interest of the child. The preamble text of the Child Protection Convention explicitly references the UNCRC as an inspiration. Furthermore, the explanatory report attributes the term parental responsibility directly to the UNCRC's Article 18 by providing that, I quote, state parties shall use their best efforts to ensure recognition of the principle that both parents have common responsibilities for the upbringing and development of the child. Here, the UNCRC describes parental responsibility as a common duty of both parents. The text continues, I quote, parents, or as the case may be, legal guardians, have the primary responsibility for the upbringing and development of the child. The best interest of the child will be their basic concern. We see here the famous best interest of the child standard. Observe that the parent or legal guardian holds specific responsibility for the upbringing and the development of the child. These ideas are a needed change from several decades earlier, where parents did not hold responsibility so much as they held authority and command over children. The 1961 Protection of Minors Convention, for example, used the term relationship, subjecting the infant to authority in its non-authoritative English text. As we celebrate 25 years of the Child Protection Convention, alongside its siblings, as I mentioned earlier on, it is important for us to take a step back and reflect also on the Africa continent, its approach, as well as its understanding and its embracing of the Child Protection Convention. The African Charter on the Rights and Welfare of the Child, also known as the African Children's Charter, was adopted in 1990 and entered into force in 1999. We would remember that during the negotiations, which began in 1988, its drafters had the opportunity to develop a regional instrument that acknowledged the unique experiences of Africa, while promoting broad principles that are also recognized in the UNCRC and the Child Protection Convention. For example, the best interest of the child are also deemed the primary consideration, and parental responsibility is defined in the Charter to include various duties for the upbringing and development of the child. Article 31 adds that the child holds responsibility towards his family and society, the state and the international community, subject to their age and abilities. These duties include to work for the cohesion of the family, to strengthen social and national solidarity, to preserve and strengthen African cultural values, and to contribute to the moral well-being of society. The Charter establishes an African community, the Charter established an African Committee on the Rights and Welfare of the Child, with the mandate to promote, monitor, and interpret the Charter. In its work and in its formal recommendations, the committee has enhanced regional cooperation and increased harmonization of national laws. Altogether, the African Children's Charter stands as one pillar of the protection framework relevant to Africa, alongside the UNCRC and the Child Protection Convention. Reverting to the convention itself, looking at parental responsibility and its definition, armed with our greater understanding of how we reach this point. Article 1, paragraph 2 of the Child Protection Convention identifies parental responsibility as parental authority or any analogous relationship of authority, determining the rights, powers, and responsibilities of parents and guardians or other legal representatives in relation to the person or the property of the child. Consistent with our initial reflections, supported by a brief look at the history of international instruments, as well as the regional instrument, that of the African Charter, we understand that the authority referred to in this definition is not the authority for a parent to further his or her own interests, but the authority to act for the care, education, health, stability, and promotion of the child. I have to step back here, reflect, and share the South African approach to parental responsibility. I note that the convention definition has an autonomous meaning in order to widely accommodate different systems of parental responsibilities found in different jurisdictions, including systems which do not refer to parental responsibility using the exact same terminology. Furthermore, the convention also directs us to national law, particularly the law of the child's habitual residence, as the source of substantive law on attribution, extinction, and exercise of parental responsibility. The constitutional framework of South Africa also reflect changes in the perception of parental responsibility. The enactment of the final constitution in 1996, including its Bill of Rights, brought about an expansion of rights afforded to children, including their rights to equality, dignity, housing, social security, and education. Section 28 of the Constitution contains specific protection for children, referring to the child's right to family or parental care or appropriate alternative care when removed from the family environment. I also draw your attention specifically to Section 28 of the Children's Act, which deals with court-ordered termination, extension, suspension, or restriction of parental responsibilities and rights. Here I quote relevant language. When courts are considering an application regarding modification of parental responsibility, Section 28, subsection 4 of the Children's Act provides that, and I quote, the court must take into account A, the best interest of the child, B, the relationship between the child and this person whose parental responsibilities and rights are being challenged, C, the degree of commitment of that person, the commitment that the person has shown towards the child, and D, any other factor that should, in the opinion of the court, be taken into account. Putting these factors together, we see that in practice, South Africa has built the modern ideals of family responsibility into its laws. The best interest of the child, of course, is the overriding principle, again, following the UNCRC. We look also to the relationship between the child and the holder of parental responsibility, as well as the degree of commitment that the person has shown towards the child. It is reassuring that this language holds the parent-child relationship in clear view and looks for the explicit commitment of the person holding the responsibility. This creates the opportunity for courts to consider what kind of relationship is needed for the growth of the child and to evaluate whether the holder of the responsibility is up to the task of providing for those needs. Looking ahead, South Africa, unfortunately, is not yet a contracting party to the Child Protection Convention. Nonetheless, the values built into its laws are consistent with international human rights standards and completely compatible with the Child Protection Convention. South Africa has the opportunity to take a leading role in defining child protection in the region, using its accession to the convention as a further signal of its commitment to its youth and the youth of the region. Africa is the world's youngest continent. UNICEF data projects that Africa's child population will reach 1 billion by 2055, making it the largest child population among all continents. Joining the convention will equip South Africa with a valuable tool for the protection of children, a tool ensuring that the holders of parental responsibility, in whatever form or name they may take, are positioned to prepare children for the world that awaits them. Once again, I wish the Child Protection Convention a happy 25th anniversary, and I look forward to its continued growth and development. Thank you for joining me in this celebration. Ke a leboha.